Thank you very much. And thank you to the organisers for the opportunity to participate in this event. I should at the outset perhaps say, because it tends to be confusing to people, that New South Wales is in Australia, not in the west of the United Kingdom. A number of people have confused that, although obviously the origins of the name go back to South Wales. I should say, I guess, at the outset that my background, as we've been disclosing backgrounds, has been largely as an academic observer of people's tribunals. As an international lawyer with an interest in human rights and human rights procedures, I've not actually been involved in the organisation or participant in people's tribunals, other than having the privilege of observing the Permanent People's Tribunal on agrochemical transnational corporations in Bangalore a couple of years ago, which was a very enlightening experience for me. But let me start with reference to an event which took place a little bit over a year ago in Sydney, Australia, in July, where a citizens' tribunal convened at the request of various supporters of West Papua groups was held to inquire into an alleged massacre at a place called Biak in West Papua, which is within the state of Indonesia, some 15 years earlier. There had been suppression, or the massacre that was alleged arose out of the suppression of pro-independence demonstrations. Many of the demonstrators were killed, many were detained, tortured, raped, mutilated, and subsequently killed, with bodies being buried in mass graves and in some cases being put on ships, taken out to sea and dumped. No proceedings had ever been instituted in Indonesia, nor taken up before any international tribunal with any significant outcome. West Papua, of course, having, in the view of some, being sold down the river in the so-called Act of Self-Determination in 1967, when a small circle of West Papuans favoured by the Indonesian authorities voted in what was an undemocratic election, choosing, as the UN noted, to integrate the territory with Indonesia. Following this hearing, which took one day and involved the consideration by a very small tribunal of live testimony, recorded testimony, documentations, reports of those who had been there at the time, a judgment was handed down involving findings of fact, holding that the allegations of the massacre were correct, accompanied by a series of recommendations, basically calling on the Indonesian authorities to conduct a proper inquiry, and to other countries with influence, such as Australia, to put pressure on them to do so. This Biak tribunal was a relatively modest tribunal by the standards of Tokyo, or indeed the impressive Iran tribunal. And yet it illustrates, I think, in a very clear way, the scope that still exists, as Sir Geoffrey has referred to, for citizens' tribunals in situations where you have essentially nothing. The West Papuan activists are trying to have the truth told. They're trying to resist the dominant Indonesian narrative. They have no political friends, near or far. Indonesia, of course, in terms of geopolitics, is someone with whom everyone wants to be friendly. And there is no formal or informal, there's no formal legal option. And so that, I think, illustrates the phenomenon of people's tribunals that has become increasingly popular in recent years. And yet I think it's important to recognise that people's tribunals themselves really have a marginalised, not a repressed, but perhaps a forgotten history themselves. Sir Geoffrey has referred to some of the peaks, the initial modern one, the first Russell Tribunal, the Tokyo Tribunal, and I suppose the Iran Tribunal. But it's important to remember that there have been many others. Indeed, there have been hundreds. And I'd particularly like to draw attention to those who have been repeat players in the field of people's tribunals and acknowledge the work done by the Permanent People's Tribunal, whose Secretary-General, Dr. Gianni Tognoni, is here, and I'd like to acknowledge his and his colleagues' contribution to my work and the work of our centre in this field. But the internet, as Sir Geoffrey said, has changed it, and I think there's an important archival project necessary for people's tribunals to realise that these vigorous and directed forms of activism and resistance in modern people's tribunals do have a history that can both inform and instruct us both in what we should be doing and what we shouldn't be doing. There has been relatively little examination of people's tribunals in any overarching sense. Focus has tended to be at seminars like this and in the literature on specific tribunals by participants in them. And so it's wonderful to have been at a conference in the last 2 days in the company of many anthropologists, which was an interesting experience for a lawyer, and also at today's conference to try and evaluate the particular tribunal that's the focus, I think, of many people here, the Iran Tribunal, in the context of other forms of activism and in the context of the history and the critiques, both the older critiques and the newer critiques of people's tribunals. And in my comments today, I'd like to acknowledge also the contributions of my colleague, Dr. Gabrielle Sim, with whom I had an Australian Research Council funded project on the topic, which also permitted us to hold a seminar last year with the Permanent People's Tribunal in Rome. The task that I have been given today is that of providing a general overview of modern people's tribunals, their development, structures and practices, their normative frameworks, their significance and the critiques. And I'm sure that others will be presenting different perspectives on some of these issues. There are 5 topics I want to touch on in the course of my comments. Firstly, the origin and nature of people's tribunals. Secondly, what I call the standard critique of people's tribunals, that of the legalist legitimacy critique. Thirdly, the case for people's tribunals, what they claim to do, broadly, which Sir Geoffrey has broadly outlined already. Fourthly, critiques from below, or what I might call the critical critiques, the new critiques of people's tribunals. And then finally, if time permits, a few comments about the relationship between people's tribunals and state-sponsored mechanisms. Let me then firstly sketch, as has already been mentioned, the broad characteristics of people's tribunals that we're talking about. And indeed, there are probably other forms of people's tribunals that need to be looked at. We're talking about bodies which are set up outside state-sponsored structures to address alleged violations of human rights and international law, or to identify deficiencies in existing international law and structures in terms of some other fundamental values, identified in the early days of people's tribunals as people's law. The goals of people's tribunals are broadly to supplement existing accounts, to highlight the gaps, the deficiencies and failures of international and national legal systems in particular, to respond to claims for recognitions of wrongs. They've been enjoying a popularity. It seems that every time you look somewhere there is another people's tribunal, and I think that gives us occasion to reflect on their utility and their limitations. Firstly then, the origins. As Sir Geoffrey mentioned, modern tribunals, at least the dominant narrative of them, trace the current practice to the Russell tribunals on the Vietnam War in the late 60s, early 70s. There are other accounts, but I think this is the most compelling one. It's the reference point that nearly all modern people's tribunals take as their authoritative and conceptual framework. They're intended to fill a gap, as the Russell Tribunal famously said, to prevent the crime of silence, to create a record and sometimes findings of responsibility, whether individual or state-based, and to come up with practical recommendations, and increasingly, I think, to become a tool for advocacy politically at the national and international level. As I've said, hundreds have been held since the late 60s. There's an enormous variety of people's tribunals, and they arise and are tailored to particular situations and to particular goals, and yet there are some common features. One of the interesting aspects, I think, is the distinction between those who have been repeat players, in particular the PPT, the Permanent People's Tribunals, the Russell Tribunals, and perhaps the less well-known Latin American Water Tribunal, which does a different sort of people's tribunal, performs a different sort of people's tribunal function.
And I think that raises interesting issues about the culture and the practice of people's tribunals from an academic point of view that's perhaps, which is interesting, but perhaps not so relevant when we're looking at people's tribunals from the point of view of a political practice as forms of resistance. But I think what it reflects is the increasing use, is increasing expectations, increasing demands for truth, for accountability, captured, I think, very often in the slogan of getting rid of impunity. The particular sorts of people's tribunals that I think we're focusing on this conference are those which might be described as international people's tribunals, often also known as public opinion tribunals, tribunals of conscience sometimes, citizens' tribunals. And I think the distinctive and the striking feature about them is their commitment in most cases to international normative standards, international law, whether based in a positive statist international law, everything from the Universal Declaration through the right to self-determination, the human rights treaties that we're all familiar with, sometimes combined with national, local or indigenous law, but also they refer, as I've said, to people's law. Although that was popular in the early days, it's become, I think, less important, and it would be interesting to explore some of the reasons why that is. And as we know, they're generally composed of members from a variety of countries and a variety of backgrounds. It is rare that lawyers dominate these tribunals, notwithstanding the international legal normative framework that is often used and is central, though not exclusively the focus. But for various reasons of publicity, of profile, of moral legitimacy, political legitimacy, knowledge, different competences, they're broader than that. And their intended audiences are not just those who ask for them to be convened, but international audiences. And one of the challenges, I think, is with people's tribunals is speaking authoritatively and with legitimacy to different audiences who may have different requirements in order to allow them to listen sufficiently and to give the tribunals weight. The other defining features, I suppose, are the commitment to a formal procedure of tendering evidence, public hearings set up to be adversarial sometimes, or at least involving some form of contention or discussion or evaluation of evidence, reasoned deliberation, and an outcome, which can vary from findings of guilt of fairly definite form through declarations of cases to answer to recommendations for actions to investigate, as in the BIAC tribunal. And another important feature of nearly all of them is that they arise out of social or political movements or campaigns. And they vary enormously along the spectrum, from that of the Tokyo Women's Tribunal, which is perhaps seen as the most legalistic of the tribunals that we have seen in modern times, to more wide-ranging ones, which seek to do a job of historical recounting as well as making findings of legal responsibility. The themes of people's tribunals vary considerably, and we see this particularly in the work of the repeat players, such as the permanent people's tribunals. They see the classic cases of state oppression against its own population or segments of it. The Iran tribunal is a classic case, but there are many others. Sri Lanka, Tibet, the list goes on. We see many cases of interstate or trans-border actions involving international law on the use of force, the laws of armed conflict and the law of occupation. Permanent People's Tribunal case on East Timor back in the 80s, the World Tribunal on Iraq held in the mid-2000s, Permanent People's Tribunal on the Western Sahara, and I suppose the most important in recent terms, the Russell Tribunal on Palestine, with its focus and its repeated hearings in relation to various aspects of international law and Israel's activities in relation to the occupied territories. The two new dimensions moving away from what might be seen as those classical elements, and perhaps of less interest here, but I think they're important theoretically in terms of the nature of challenges and the potential of people's tribunals, are the way in which they have begun to examine violations of rights by transnational corporations, which of course often involve the active or passive complicity of host states or even the home states of those corporations. And once again, the work done by the Permanent People's Tribunal on transnational corporations in Latin America is perhaps the most extensive, but not the only example of this. And the final category, I think, are those critiques of international law and international governance regimes that facilitate or encourage the violations of the rights of local populations and peoples. So a stance which takes international law itself as problematic, or at least some aspects of it, and seeks to critique and remake that in the light of the rights of peoples, focusing on various respondents, international organisations, World Banks, international financial institutions, and so on. Independent Tribunal on the role of the World Bank in India is one example, and of course the Permanent People's Tribunal have done work of this sort as well. And the other major distinction, I think, between formal legal tribunals, even the top-level international tribunals such as the International Court of Justice or the International Criminal Tribunals, has been the role that people's tribunals see themselves as playing as not just identifying violations and assigning responsibility to an individual state or to a particular individual, but they seek to understand the causes, to describe the history, to tease out the deep structures of power relations, of oppression, and to address that as well. And one of the questions is how well they do that. It responds to an important need in terms of the users. It's also given rise to criticisms of them. Let me then move to the standard critiques and scepticism about the utility of people's tribunals. They're probably well known to you, and if they're not, you could think of them, no doubt. Criticisms of people's tribunals in general come not just from formalistic legal perspectives of the lawyers concerned that people are trenching on their established patterns of ways of determining liability, but from political, philosophical and pragmatic political perspectives as well. Broadly speaking, they fall into two related categories: people's tribunals' lack of legitimacy and their lack of efficacy. The attack based on lack of legitimacy is articulated in various ways. The critical features being that these are self-appointed, deriving their existence and their authority neither from the nation-state nor from the state-based international community. A critique brilliantly captured, as many of you know, in the famous exchange between Charles de Gaulle and Jean-Paul Sartre in relation to the critique of the first Russell Tribunal, in which de Gaulle said that justice, or asserted that justice was the monopoly of the state, and that the People's Tribunal had no business in setting itself up as an instrument of justice. There was a much less edifying and less theoretical exchange between Bertrand Russell, I think, and the Americans on this issue, but the de Gaulle-Sartre one captures, I think, those very important notions of the nature of justice and who owns the law. They've been variously described, certain tribunals, the first Russell Tribunal, famously described by Richard Falk as a juridical farce, although Richard Falk, intriguingly, has been a very enthusiastic People's Tribunal member, and everywhere from Hawaii to many other places. Or, in the context of a recent Kuala Lumpur tribunal, in rejecting the characterisation of it as a motley collection of vigilantes. So the notion of a particular model of justice and the temerity and the gall of people outside formal state institutions to set themselves up as administering a form of justice, whatever justice may mean. The notion of bias and prejudgment is often levelled. Everyone knows what the result of a people's tribunal is. There are rarely, if ever, dissents. And it is therefore argued that this discredits the tribunals, which in most cases are organised, funded by those who have a particular interest in the cause. Biased outlook, and the members, of course, are said to have a biased outlook, a predisposition, at least in general, and sometimes very often in relation to the specific issues before the tribunal. And of course, the well-known chestnut of procedural unfairness, the fact that defendants generally do not appear before such tribunals, although they're nearly always invited. So that's the legitimacy issue. The efficacy issue is related partly to legitimacy, but also to the pragmatic impact. The notion that they're not formally binding in terms of their results, therefore they cannot produce a result, as if the formally binding pronouncements of international courts always produce a result. And in any case, as an empirical matter, they have little or no impact. And therefore, they're a waste of time. People who engage in them are deluding themselves, and the organisers are deluding those who have expectations raised about a concrete outcome that might result from such a performative act. So I think that's very much the classic formalistic claim, which has a narrow understanding. What are the ripostes? The ripostes, I think, are a number, and I'm sure they're well known to you as well. That the argument put forward in the Russell Tribunal and the subsequent tribunals is that legitimacy comes from the failure of the state and the international community, as Sir Geoffrey outlined, to give effect to their own standards. And that in any event, the source of authority of the state and that international community lies at bottom in the people, in the populace, in the citizenry, something reflected in orthodox political theory and also arguably in relation to the international community. The argument, they also argue that legitimacy comes not just from the source of authority, that there are many other sources of legitimacy in the way in which we accept social practices and findings. And they can be the credibility of the particular speaker, so the stature, the moral status, the expertise, the nature of the proceeding, that is the deliberative and evaluative and transparent nature of a process, and the reasoning. And of course, it can also come from recognition. In terms of efficacy, I think this opens up the specific issues that people's tribunals very often seek to go beyond what courts are doing. Yes, formal courts, formal institutions of justice are about finding legal truths. They're about assigning responsibilities in many cases. And certainly people's tribunals do that in different ways. But they also perform, or they're said to perform, other functions. The important validation of experience. And I think Iran, some of the clips I've seen from Iran make that very clear. When people are listened to seriously and with empathy, and their experiences are validated, not just by being given that respect, but also by the legal characterisation of them as wrong, which seems to be important in many cases, not always, but there's something about the power of law and a finding of law which does have a particular resonance and importance in many contexts. There's also the archival role, and we've seen this in a range of issues, and Sir Geoffrey referred to it, and I suppose the classical examples really are the Armenian genocide tribunals, once again the PPT that seems to be, have done it all in many ways, in terms of keeping issues alive, in making accessible to much broader audiences materials for those audiences to evaluate independently, not just to take it as understood. And then, of course, the process of solidarity and momentum. Anyone who's been at a people's tribunal can sense that. It's often associated with the musical events which seem to accompany people's tribunals, but there is a sense of solidarity, of support, of building momentum, of validating the struggle that underlines the people's tribunal. Well, the issues, though, I suppose, and this came out at this conference of the anthropologists, was these are the asserted verdicts. We've got anecdotal evidence. People say this when they go to particular tribunals. And you might say, well, they would, wouldn't they? It's a self-validating process. That's probably true. But in terms of overall work on these tribunals, we have really very little empirical work unearthing these issues and documenting these in a systematic way. And that, I think, would be very useful, not just for understanding the phenomenon, but helping to design more effective people's tribunals, if that is the way, one of the strategies that is going to be used in the cause of human rights. So that's the counter-argument. That's why we have them. Well, then, of course, there's a new range of critiques, common to some extent to critiques of formal procedures about human rights, but ones which I think emerged very much from those who work with the persons whom people's tribunals are meant to serve. They are the issues of representation and representativeness. Who speaks for the victims and survivors and sets their priorities? Who decides that there will be a tribunal and the standards that will be applied? What distorting effect does a tribunal have? Yes, there are various truths, but once you start to put things, particularly mediated through legal concepts and lawyers, how does that distort or skew the truth, the story, the experience that people have had? And so the top-down, the imposed conceptual frameworks. And the other issue which emerged very interestingly in the anthropological focus conference that I was at a few days ago was people's tribunals have historically been very focused on a form of justice which involves charge, evidence, assessment, verdict of responsibility. That is not always, it seems, what the victims, the survivors, however they are depicted, want. Sometimes they just want the opportunity to tell the story. Sometimes they just want the opportunity to have their suffering recognised and empathised with. They may not want the legal condemnation, the legal form that takes. And I'm sure that my compatriot Tina Dolgopol will be talking about that when she talks about the Tokyo Women's Tribunal. But that was something very much that's emerged in the context of some of the work done around truth commissions, truth and reconciliation commissions, legal proceedings, particularly in Latin America in transitional regimes. And I think it applies equally to people's tribunals, particularly given the enormous resource constraints that people's tribunals face. If you think of the International Criminal Court or the ICTY with budgets of hundreds of millions of dollars, people's tribunals are doing these things on relative shoestrings, and they're trying to respond to so many needs. How it's extraordinary, really, what they manage to do, given the resources that they have. The final point that I want to address is to talk very quickly about the relationship between formal state-sponsored procedures for human rights and people's tribunals. As we've seen, it's a consistent theme in people's tribunals' justification of their legitimacy is that they're closing the gap or covering the gap. And that in the light of the evidence of widespread rights violations, violation of human rights norms, national and international, the failure of domestic systems to provide a forum means that there is no remedy. And therefore they're just substituting for the failure in the state-based system. That was clearly seen and articulated in the first Russell Tribunal. And it's interesting that those who set up the first Russell Tribunal saw themselves as a sort of placeholder for the Nuremberg Tribunal, the International Military Tribunal that took place after the war, which was a classic, well, in some ways, criminal tribunal in which individuals were put on trial, convicted and sentenced, even though they said they were not doing this. The comparison, I think, was the nature of the charges and the finding of responsibilities of the states involved, the United States and its allies. But they were clearly assuming that, hoping that there would emerge a permanent international criminal tribunal. It eventually did, and that to some extent, therefore, the task of people's tribunals would disappear. But of course, we know it didn't. There are many violations. The International Criminal Court, for example, has very limited jurisdiction. But it is true to say that since the 1960s and early 1970s, the available state-sponsored avenues are extraordinarily widespread now. We have whole ranges of international and regional human rights bodies and mechanisms that are of the hard law nature, European regional human rights system, the Inter-American system, the emerging African system. We have the softer United Nations Human Rights Treaty bodies, we have special mechanisms, we have a whole range of fora within which states and other actors can be held to account. So one of the questions I think we have to ask ourselves is, how does this change the way in which we see and work with people's tribunals? The fact that there are so many other mechanisms, does working with the people's tribunals undermine the possibilities there, or is it a synergy? And that, I think, goes back to questions of strategy, to questions of opportunity, as to how one uses the outcome of the people's tribunals process in order to independently or in order to activate some of those procedures. So Geoffrey alluded to the fact that perhaps one of the impacts would be to activate the formal proceedings. That may be. I guess that's something we might want to test empirically. One of the other issues that's arisen is, does the way in which people's tribunals carry out their work perhaps undermine or cut across the possibility of some of these tribunals performing their work? And one of the areas in which this has been quite difficult is those cases in which non-state mechanisms collect evidence. If the goal is ultimately a criminal tribunal before a formal tribunal, how can one collect evidence in a manner, or should one collect evidence, and how one can collect it in a way that it might be usable and that it won't involve the re-violation of the victims over and over again if they have to give their accounts to a whole range of different actors. And I think that that's one of the major changes in the landscape, and I think we have seen the ways in which various tribunals have sought to work with them. Sometimes they can replace the formal procedures, sometimes they can be a precursor to them, sometimes they can go on at the same time. So, for example, with Sri Lanka, we have had people's tribunals interacted with the UN Secretary-General's panel of inquiry and now Office of the High Commission on Human Rights report. So they can have that stimulating effect. And sometimes they can be a supplement, or I suppose an implementing agency. You might say the Russell Tribunal on Palestine certainly saw itself in its first phase and perhaps ultimately as helping to give effect to the advisory opinion of the International Court of Justice. The Tokyo Tribunal, I'll leave that to Tina to talk about how that interacted with official mechanisms, but there were some. Sri Lanka I've spoken about. And the tribunal for the PPT ran on the former Yugoslavia also had some interaction with the ICTY. Though it's not entirely clear how that interaction took place, whether it was just words on the page. So let me then conclude with a few challenges in linking the formal and the People's Tribunal format. The challenge. No, I won't talk about I won't talk about those challenges. But I think one of the major difficulties, and it is a challenge, is that whereas people's tribunals are seeking to generally draw a history, come out with causes, to have a contextual explanation, the focus of international tribunals formally tends to be very much narrower. When you're talking about the individual criminal responsibility of a person, then the way in which you go about making findings is fundamentally different, I think, in a number of respects from how you go about a more general description of a state's responsibility. But let me then conclude, and I think the view that certainly I and many others, I think, take is that people's tribunals exist as part of a spectrum of mechanisms that are available, that one doesn't have to get hung up on the state or non-state distinction. And indeed, one of the benefits of working with, speaking with those anthropologists, colleagues with whom we met, was that anthropologists see meaning in social practices and that the state versus non-state distinction is not necessarily a critical barrier. What we have is a range of mechanisms for addressing human rights violations. The mechanisms of the formal sector are very much more extensive than they once were, but they're still limited. While some of what people's tribunals can track the work that formal tribunals do, their legal status and practical constraints limit the extent to which they can replicate the work of state-sponsored tribunals, if that is their goal. Nevertheless, the formal processes of people's tribunals, the deliberative decision-making processes, and the nature of their findings and the truths that they seek to tell can obviously contribute to the acknowledgements of wrongs and stimulate action to redress them. And, as Sir Geoffrey said, at the same time, people's tribunals can supplement or spur on the work that existing or potential state tribunals may do, and can also perform many tasks that state-sponsored tribunals cannot do as well or cannot do at all. Thank you.